Well, good afternoon, and thank you for joining us for today's Business Success Series presented by Manulife on COVID-19 vaccines and what they mean for your return to work office plan. My name is Ian McLean, and I'm the President and CEO of the Greater Kitchener-Waterloo Chamber of Commerce. Before we get started, I would like to take a moment to acknowledge that we do live and work on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples, as we seek a renewed relationship based on a foundation of mutual understanding and respect. As participants in today's virtual event, we are coming together as one. We believe everyone is free to be their true self and receive the same respect and opportunity, regardless of age, ethnicity, gender, culture, identity, sexual orientation, beliefs, or language. We hope you will join us in fostering a positive environment here today that is a safe and welcoming space for all. We know there is more that we can do, and we are committed to listening, learning, and growing as we go. Today's session would not be possible without the continued support of our sponsors and partners. So a special thank you today to our title sponsor of the Business Success Series, Manulife, our Platinum Series for the series, the Immigration Partnership of Waterloo Region, and September's sponsor, Gowling WLG. These organizations and many others are committed to supporting our local economy and providing businesses with the resources and tools they need to thrive. Just before the session starts, I'd like to go over a few quick reminders. Please do ensure that your microphone is muted throughout the presentation so we can reduce any background noise. If you have a tech-related question, please comment in the chat section and a representative of our team will get back to you momentarily. If you have a question today for today's speaker, they will be gathered throughout the session and our speakers will do the best to answer as many questions as possible following the presentation as well. Please do put those in the Q&A section on your screen. All attendees will also be sent a recording of today's presentation and will also be made available on the Greater KW Chamber website. So at this time, I'd like to take the moment to introduce our guest for today, Melissa Roth. Melissa is a partner in Gowling WLG's Waterloo Region office, practicing in the Employment, Labor, and Equalities Group. Melissa regularly advises and represents private and public sector employers on a wide range of issues, including human rights, wrongful dismissals, employment contracts, grievance arbitrations, collective agreement negotiations, policy development, workplace investigations, and occupational health and safety. Melissa has appeared before administrative tribunals, arbitrators, courts, and mediators. While Melissa's practice encompasses many areas of labor and employment law, she has extensive experience appearing before the Human Rights Tribunal of Ontario, helping her employer clients deal with claims of discrimination, accommodation, and harassment. So please join me in welcoming Melissa. Thanks for joining us today.
Thank you, Ian.
Now, just as we get started, and I think this is something we talked about as we were getting prepared for today's session, Melissa, while you are a lawyer and a good one, and WLG or Gowling's WLG is a great firm, this does not constitute our question and answer, and our discussion today doesn't constitute legal advice. If people have, we can give some general ideas of questions to ask and things that they should consider as they're making their own plan, but you really should get professional advice from your own advisors in your own business, your lawyer, your accountant, and others as well. So I just wanted to make sure everyone was aware of that. The advice and the direction that we'll talk about today are good guidelines, good questions that people should be asking as we get started. So let's dig in. And before we get to, because we've talked about a number of the subject areas we want to cover, Melissa, I think it probably bears for the people, business owners and entrepreneurs that are listening today, where are we at in the pandemic? Just in terms of vaccinations, vaccination rates, all the things that will impact our discussion today in terms of returning to work. Why don't you give your kind of assessment of where things are at as we start the conversation today?
Absolutely. Thank you, Ian. Well, it definitely, as Ian mentioned, this is a very dynamic area of the law. Things are changing by the day. So always recommended that before taking any steps, you reach out to your legal advisors for updates and advice on best practices. We can start with some stats today, and I tell you that, as you may know, vaccination data for Canada is updated on a weekly basis, every Friday at noon. As of September 10th, 77.49, so almost 77.5 of eligible Canadians 12 and older are fully vaccinated. So we're getting there. And in Ontario, the number is 84.49, which is 84.5 of the total eligible population has received at least one dose of COVID-19, and 78.2 of Ontarians have received both vaccine doses. So we're at a pacing well, but we need some more numbers there. The end of the pandemic is not over. We are in the middle of the fourth wave, and with the schools and everything else starting back up, we can probably see that there may be some additional measures that are implemented by the government.
Yeah, I think it's important that while we've made tremendous progress, especially here in Waterloo Region, with when we were the hotspot across the province for Delta not too long ago, 2 or 3 months ago, we really stepped up and got our vaccination rates up, but we're not out of the woods yet. And so I think it's really important. Certainly something the Chamber's been doing right along is encouraging everyone who's not vaccinated to get vaccinated, because at the end of the day, the fastest and quickest and surest way to get through and past COVID, so we can fully reopen the economy and our communities, is for people to get vaccinated. Because it's all the experts would now say that we have to be north of 90% double vaccinated to really be past this the crisis that we're in. Okay, so having sort of done that little setup, because I think it's important that the measures and the things we're going to talk about in terms of reopening your office, as some will happen sooner rather than later, but it will happen over probably the next 6 months or so as businesses are more comfortable depending on their sector. It's going to look different for everybody. But we have now been working in a remote environment for, in many cases, over 18 months, since many businesses have not fully reopened since we started the lockdown in March of 2020. And I guess the question many businesses would have is, can they mandate their employees to return to the office? And I guess let's start there, and then we can talk about what comes from that.
Absolutely. Well, generally speaking, employers have the right to require employees to return to the office. An employer has the right to determine where employees perform their work. However, a lot of that will depend on what is in the employment contract. So we need to start by looking at the language of the employee's employment contract to see if there are any terms in there about location or remote work, or telecommuting as is often known. So the fact that many employees worked remotely during the pandemic on its own should not make the work from home arrangement a new term of employment. Employees can generally be mandated to return to the office in person if that was their pre-pandemic work arrangement. So we have to still look at other aspects, however, not just the employment contract language, because before employers recall employees in person, they have to make sure that there are appropriate safety protocols in place. A failure to ensure a safe workplace can lead to liability under occupational health and safety legislation. And also, once the safety protocols are in place, there may be other limitations on mandating that all employees return to the office in person. So for instance, if an employee cannot return to the office for valid human rights protected grounds, then the employer has a duty to accommodate the employee under the Human Rights Code. Some of those human rights protected grounds can be childcare obligations that fit under the ground of family status, or elder care obligations that also fit under family status, or employees who have a health condition that may require accommodation. Allowing employees back into the physical office space is of course subject to government orders and restrictions. As we hear about the COVID-19 projections for the fall, there very well, as I mentioned, there very well could be another shutdown or certain workplace that may have to close or may force employees to work from home again.
So let's drill down a little bit on that, because I think that would be an area of concern, especially for many of the audience watching today will be small and medium-sized business where it's not as easy to make accommodations in a small workplace, or it's more difficult to manage in a small group. When you talk about if that was the way of working before COVID, you can ask them to come back. When you talk about the accommodation for things such as childcare or elder care, would that be directly related to the pandemic itself? Because that would have presumably been in place before the pandemic as well.
Well, you have to look at this from two silos almost, which are definitely interconnected. So there are the obligations under the Human Rights Code, which are obligations that, as you noted, obviously existed before the pandemic. But the pandemic may have caused changes to those employees' obligations with respect to elder care, because perhaps now people who did not need elder care are staying at home and as opposed to being in a congregate setting, or children who before attended school in person are now, their parents have chosen to school them at home through online learning. So there's the human rights aspect of things, and there's also the Employment Standards Act aspect of things, which we will talk about it as well. But that, those very same reasons that I just mentioned, for instance, childcare obligations, elder care obligations, or medical conditions, also will likely fall under the entitlement to infectious disease emergency leave under the Employment Standards Act, or ESA. Infectious disease emergency leave, you might hear me call it IDEL. So IDEL is an ESA protected leave, and the employee is entitled to it, regardless of whether the employer wants to provide them with the leave or not.
So as we think about mandating or saying our office is reopening, expect everyone to come back to the office, that's a reasonable step for employers should they decide that's right for their business. What are the risks in doing that? And is there a middle ground? As an example, I can imagine, I've talked to lots of business owners who have said that they're not going to go fully remote. There have been some that highlighted in the news that have said they're going completely virtual. That will be a very small number of businesses. Most will go back to some form of hybrid for many employees, not all, but many, where they'll work at home a couple of days a week and be at the office. Does that make a difference in terms of that mandate to return people to the office? Like in terms of looking at what the risk profile would be for a small business?
Well, definitely each situation will have its own risk, depending on the circumstances, depending on the plan that the employer implements, depending on the type of workplace that we're dealing with. Many employees may not want to return to work because of things like the commute, or because they prefer the flexibility of working at home. And those are the types of things that, say, for employee morale, the employer does not have to accommodate in the legal sense of the meaning of accommodation under the Human Rights Code, if it's based on preferences. Some employees may also feel uncomfortable, and I'm going to put uncomfortable in quotation marks, returning to work because of COVID. And those are the ones that we will need to unpack a lot more, because we will need to realize whether that discomfort is based, again, on just a personal preference or on a human rights protected ground. So where the employee is hesitant to return to work because they're worried about safety measures in the workplace, they might engage in work refusals. There has been hundreds and hundreds of work refusals since COVID started, since the pandemic started, and a lot of them have not been upheld by the Ministry of Labor. When a work refusal happens, the employer will have to investigate the concern. If it cannot be resolved, then a Ministry of Labor inspector will investigate and provide an outcome, a decision. And where the employer is taking the proper safety precautions, it is unlikely that the employee will have what's known as reasonable grounds for their work refusal. Even so, going through this process can have a negative impact on employee morale in the whole workplace, as I mentioned before, right? So we might be dealing with issues of morale, and a hit to employee morale can sometimes lead to talks of unionization. So there are a lot of different aspects of this decision that the employer has to consider. Other risks in making employees return to in-person work is that they may choose to resign and find a new job that allows them to work remotely. And we're seeing a lot of that happen, and a lot of employers are dealing with employee retention. Employers don't want to lose good workers, so many are considering partial remote or other flexible work arrangements simply to retain employees and to retain talent.
Yeah, and I think we're seeing that more and more. There certainly is a talent shortage across the board, and it cuts right across every business sector, technology, even manufacturing, retail, hospitality, and tourism as it starts to reopen as well. Okay, I guess one of the questions that often gets asked, I see it on the news, I see it in the questions that I get from our members throughout the chamber network. And the question goes, as we start to see vaccine verification programs, there are some mandates depending on your employment with, as an example, the federal government or even the provincial government. Some sectors are mandated to have vaccines. Can an employer make vaccinations mandatory for employees? And I guess this is more of a general question because people are wondering what are the boundaries for an employer as in regards to mandating vaccines for their employees.
Well, that's kind of opening the Pandora's box for answers, right? And so, I mean, this is, again, a very dynamic area of the law. Although there are some organizations that seem to be introducing mandatory workplace policies, the legal implications are not yet clear because the policies have not been litigated. There are some decisions in unionized settings regarding testing that are favorable to employers, but the case law is still developing. While we have yet to see an arbitration decision on mandatory COVID-19 vaccinations, or at the very least that I'm aware of as of today, arbitrators have in the past found mandatory flu vaccines to be unreasonable in some circumstances. As I mentioned, however, more recently, an arbitrator ruled that a mandatory testing policy for Ellis-Dawn was reasonable, which may signal that arbitrators might be prepared to uphold reasonable vaccination policies. But, for instance, with this one, the particular testing policy, the test that was being used was the less invasive rapid rapid test as opposed to the deep nasal swab. The testing was also done in that decision, and these are the factors that the arbitrator considered. The testing was done on site by external nurses with steps taken to ensure that the health information was kept private. So it wasn't done by employees of the employer. The swab was collected for the sole purpose of the test and disposed of in front of the employee. And so based on that, the arbitrator upheld the policy, saying that the policy was reasonable in light of the current circumstances. There's also the other aspects that the arbitrator considered and said that the construction industry has a high risk of spread as subcontractors travel from site to site and physical distancing is often impossible. So that combined with the past outbreaks that the employer had on its sites and the policy's objective of preventing the spread of COVID-19 led the arbitrator to rule that the policy was reasonable. But as you know, arbitrations are in the unionized context. So, it is yet to be seen whether a judge would find that a true mandatory vaccination policy constitutes constructive dismissal, or that any negative steps taken such as the ultimate termination of employment for cause, would constitute a wrongful dismissal. That being said, an employer cannot force an employee to get a vaccine because they cannot require somebody to undergo a medical procedure. So that's where I say mandatory, quote unquote, because the other aspect of a true mandatory policy, so let's say we have an anti-violence policy in the workplace, and a severe act of violence takes place, and employer says, you knew the policy, you were aware of it, and you violated the policy, I can prove it, I'm going to terminate you for cause. That's what a mandatory vaccination policy would be. It would be if you do not get vaccinated, you are terminated for cause. The ability to do that will be very limited for an employer. An employer may introduce a vaccine policy in the workplace, and whether an employer will be able to make it really mandatory without liability is going to yet to be seen. In other words, when an employee refuses to get vaccinated and there are no protected grounds involved, can there be consequences such as disciplinary measures for non-compliance, including termination for cause?
I guess it leads to, because I know we can't get to definitive yes or no because it's unknown right now. But is the watchword of this is to try and be reasonable in your approach, because many businesses, partly why the vast majority of businesses are in favor of vaccine verification program with the province or the federal government for that matter, is that that the government is providing this tool and a business can choose to use it. People always have and I guess this is the issue. An employee always has the option of saying, no, I'm not going to be screened. No, I'm not going to get vaccinated, or let you know my status. But then it also puts the responsibility on the employer because they have a responsibility to have a safe workplace. So how do you square all of those pieces together? There's the individual part, but the employer has a collective responsibility to every one of their employees and their customers for that matter.
Yeah. So the employer has to first determine, whether the policy would be reasonable in their particular workplace. So for example, the importance of a mandatory vaccination policy would be different for someone who works with vulnerable individuals, such as in long-term care settings, versus someone whose job involves working alone or with a couple of people in an office. So really, that's where the reasonableness comes. We need to look at the cases in the area that the employer operates, at the type of work that they are performing, at the level of risk that there is in the workplace. Any mandatory vaccination policy needs to balance the employee's human rights and privacy interests against the legitimate safety risk posed by COVID-19 and the legitimate objectives that you're mentioning employers need to maintain, such as maintaining a health and safety workplace. So as of right now, it seems that only a handful of employer policies that have been announced in the media are truly mandatory vaccinations, such that in order to continue working, employees must get vaccinated. Many other employers are offering alternative measures, such as frequent testing, for instance, rapid antigen testing for those who cannot get vaccinated or who choose not to get vaccinated, mandatory education programs. In Ontario, again, there are certain high-risk settings that currently must develop a vaccination policy, like in healthcare settings and congregate care settings. But employers will also have to consider alternative measures to a vaccination policy. So employers should consider things like administrative or engineering controls that may be sufficient to protect employees from the risk of transmission of infection of COVID-19. Engineering controls may include things like physical barriers or ventilation systems. Examples of administrative controls includes physical distancing, alternate work scheduling, cleaning and disinfecting policies. Regular rapid antigen screening may also provide an alternative, although there seems to be mixed opinions on that from the medical field, or at least a supplementary tool to manage the spread of COVID-19 in the workplace. So ultimately, if an employer is going to mandate vaccination, a clear vaccination policy is the first step. This is key in minimizing legal risks associated with employment or privacy or human rights issues. The vaccination policy has to be in writing. It has to be communicated to employees, and at times it will have to be communicated externally, for instance, as applicable to contractors attending the workplace. And the policy will have to clearly outline the purpose of the policy and how it will be implemented and enforced. So once you have established that mandatory vaccination policy, and you implement it in the workplace and you educate your employees in the workplace, then it is equally important to consider the scope of that policy. Is it going to apply to employees only? Is it going to apply to visitors and contractors? You should also consider the effective date of the policy, because it is important to provide a sufficient amount of time to allow unvaccinated employees an opportunity to get vaccinated in order to comply with the policy. And then you'll also have to think as an employer whether your organization is going to require proof of vaccination And if so, what will be considered sufficient proof?
There's a couple of questions I want to dig in there, but I think one thing that is clear is that most businesses are asking these questions about how to handle their own employees and their customers for that matter, because what they can't do again is close. If they close again, they're not ever going to open up again because they're on their, this is we can't have another general lockdown. So what I hear you saying, and what I think is not to overly complicate it for the folks, is make your decision about what you want to do for your own business, and then you have to be clear about and have it written down. But it sounds to me like there's some general questions to ask, and that you need to be prepared to answer as you're developing your own policy, so that there's clarity on it. It doesn't need to be long, but it needs to be clear about what you're asking people to do. So some of the questions that have come up: can you ask for proof of vaccinations, as an example, for your own employees? Because it is personal, private health information. Can you ask people to attest? And that's ultimately what it is right now, an attestation that you've had a vaccine. Are you able to do that with your employees?
Okay, yeah, so you'll see certain organizations will require proof of vaccination, and then you're going to have to consider what's sufficient proof. Obviously, once the province introduces, hopefully in October 22nd, the QR code with the app, it will make things easier. Or are you going to simply accept an employee's confirmation of their vaccination status? Generally speaking, you can ask for proof of vaccination. The Ontario Human Rights Commission has said that requiring proof of vaccination may be permissible, where the requirement is made in good faith and is reasonably necessary for health and safety reasons, right? So again, your policy will have to be attuned to all of these realities of your workplace. So with Ontario's new vaccine passport, hopefully starting on October 22nd, the province is requiring proof of vaccination in certain settings, and proof may be through the enhanced vaccine certificate and the app, which can certainly become a handy tool for employers requiring proof of vaccination. But employers can also ask for proof of vaccination from their employees in other ways. Some are using an honor system, but where the employer is worried that employees may not be honest, then it is generally acceptable to ask to view proof. However, if you're going to start thinking about retention of proof, that will be subject to privacy legislations, and employers will have to consult counsel to develop an appropriate policy with appropriate safety privacy protocols for the retention of that information.
And that starts to get complicated, but I mean, if that's where you're going, retaining that information, what would be the reasons to? So as an example, holding on to personal information like that, if you have the digital QR code, you could have everyone screen every day as they walk into the building, because it will not retain the information. All it does is verify that you are either vaccinated or have had a negative test. Is that another way which you're not doing it once, you can do it every day? Because some people may not be vaccinated, but if you're giving the testing option, is that another option to do it on a every time you come into the workplace?
Another option so yes, an employer can use once this becomes available, that can be something that employers use.
Yeah, and getting that information and holding on to it, as you say, does get complicated, because now you're subject. You've got personal information, you've got responsibilities under the Privacy Act, etc. So that there's a whole other set of issues that you need to consider. There would be lots of employees will say, I know I'm double vaccinated. I want to make sure that the rest of my colleagues are double vaccinated as well, because we do know that the Delta variant it can have what they call breakthrough cases on those that are double vaccinated. But certainly if you're unvaccinated, it is more likely to make you ill, and then you have the opportunity to spread it to others. Can you share the status with either specifically or in general about your full staff's vaccination?
So sharing specific employees' vaccination status it is not really recommended unless you have, of course, the voluntary consent of the employee, as this is personal information of the employee. Employers who see this as a potential competitive advantage can consider asking employees to voluntarily disclose this information. And if an employer is going to do that, then the employer has to seek the employee's voluntary consent in writing. And it has to be truly voluntary, meaning where the employee doesn't agree to disclose the information, then there can't be any negative consequences for that choice that the employee has made. Also, employers who have stats of their employees' vaccination status, says generalized stats, anonymized, if they're truly anonymized, if there's an option to truly anonymize that information, then they can share those stats with their staff. In cases, and I say truly anonymizing it, because if we have a workforce that is of 2 people, and you're gonna share that 50% of them are vaccinated, that's not gonna be true anonymized information. But some employers have chosen, for instance, to conduct anonymous SurveyMonkey type surveys, right? That it's just not collecting anything, it is not collecting any of your personal health information, but it allows them to say, look, our workplace is 95% vaccinated. And that seems to provide some level of comfort to employees.
Okay. There's a question here that's come into the Q&A box, but let's start with this. The premise of the question being, what can employer do about employees who refuse to get vaccinated for any number of reasons? One of the examples that one of our attendees put in is an employee who is scared of getting the vaccine based upon having had a very severe reaction to a flu shot. The employee has agreed to do regular testing, follow all the other safety guidelines, etc., and has no problem with the regular testing, has offered that up. So I'm just wondering if you have someone who refuses, would that fall into that case by case basis of saying, okay, know that you're not, here's what you're going to do, because if you're going to be around the rest of employees, this is what you need to do, or make an accommodation that allows them to work at home? Would that be the type of scenario where it's the exception rather than the rule that's going to take more time?
Well, your policies will have to deal with the alternatives to vaccination. I have not yet seen a policy that will say vaccination is the only way. So we're going to have alternatives. But when someone refuses to get vaccinated, then the employer has to first inquire as to why the employee is refusing to get vaccinated, right? So if an employee has a bona fide assertion of a human rights ground for being unvaccinated, then the employer has to be aware of this and comply with the duty to accommodate as it applies. So the 2 grounds that could be applicable to a refusal to get vaccinated would be based on disabilities and creed, okay? However, disability-related grounds are very limited, and they're limited to 2, and the employee has to show medical proof of that. And the 2 grounds are an allergic reaction to the vaccine ingredients confirmed by a specialist, which has to be an allergist or an immunologist, or heart inflammation conditions that occur as a result of the vaccine. So there's recent human rights decisions that suggest that a personally held belief against receiving a vaccine is going to be insufficient to establish a creed-based ground of discrimination, because creed is much broader than just religion. So those are the considerations that we have to take. And if an employee cannot get vaccinated because of valid human rights reasons, then we need to take alternative precautions. We may need to, do certain things to keep everyone's safety in the workplace. So we may have to require unvaccinated individuals to continue to wear masks or face coverings, even if that gets lifted, or requiring regular testing, or allowing employees to work from home.
Okay, now, I want to shift the screening a little bit. One of the questions Katie has written in here is saying that they've if an employer is required to attest to their clients that they're vaccinated, et cetera, but they're not, and you do have the provision for having done a test 24 or 48 hours in advance, which I think I hear you saying would be one of those alternatives in the absence of vaccination. But the question comes up, and I'm glad to, I think I've got a bit of a response to this. Who's responsible for getting that? If you make that the option, is the business responsible for providing the testing kit, or is that an employer cost, or is that an employee cost? Now, the good news for everyone is that the Chamber of Commerce is distributing, and we've distributed over 400,000 kits in Waterloo Region alone, which are free of charge to any small business with less than 200 employees. So they can get them free. But I guess it really falls down to whose responsibility is. If you're not going to get vaccinated, is it your responsibility to make sure you're getting that and talk to your employer, but do that screening, or is it the responsibility of the employer to provide the tools necessary to use that option?
This is one of those things that, again, there is no definitive answer as of right now because it hasn't been litigated. However, our predominant view has been that, you know, if the employer is going to require an employee to undergo testing, then the employer provides the testing. You know, under most circumstances, when an employer makes something a requirement, then the employer provides that to the employee. Again, it will depend likely on the circumstances, but for the most part, we're seeing a lot of employers are providing the testing free of charge to employees, and either the testing gets done at home, in which case this is not paid time and it's done at home within certain parameters, as you mentioned. And when the testing is done at the workplace, again, most employers are seeing it as you know, work time as well, paid time. So, you know,
So as I guess one of the questions is, you can't make screening mandatory because again, it would, even though the screening kits that are available, the Abbott screening kits that are made available through chambers right across the province can be self-administered. You cannot obligate someone to do, because it amounts to a screening procedure. But can you make that you know, as an option of either being vaccinated or doing the screening? In that way, can you make that as an option mandatory?
So the answer to all of these questions goes back to the principle of constructive dismissal, right? And so are we implementing a unilateral fundamental change in the terms and conditions of a person's employment? And so again, it's the same as with the mandatory testing, mandatory vaccination. The decisions out there from the arbitral context help us, lead us to believe that at least the measures that are taking that are reasonable, and that when the employer is providing alternatives, appear to be fine. But we still have to see cases from the courts to determine this. For instance, you might have heard, or some people might have heard, that the Supreme Court of Canada has announced that employees will have to, all Supreme Court of Canada staff will have to be fully vaccinated for the fall season, and other courts are following suit. But the Federal Court of Appeal, the Chief Justice, has clearly stated that he will not disclose personal views or institutional policies to maintain the impartiality of the court when cases come up to them. Meaning this is going to get litigated. There's going to be people that are going to claim constructive dismissal, or if they get fired for not complying with any of the alternatives, then they're going to file for wrongful dismissal. And we're going to have to see how the courts decide on this, because it is not a settled legal issue.
So there's a couple of questions that come in, and I think it follows on to whether you can have mandatory screening, and so I'll give you a couple of examples, and then we can kind of use it as the general starting off point. Some folks have employees who refuse to get vaccinated, which is a personal choice, but want to come back into the office right away. But they also then refuse to do regular testing. You know, what can you do in order to protect the full staff? The second one, which is around that, is someone not wanting to get vaccinated, saying they're okay to do a test, but then putting up the roadblock of saying they're not sure about the chemical, and there is no chemical in the Abbott swabbing kits. There's an activating agent, which is like saline effectively. but you get the idea. People saying, I'm not going to get vaccinated. I'm prepared to do certain things, but then putting up roadblocks to every one of the options that you put forward. Ultimately, the issue that I see is employers have to protect all their employees, not just the ones that are saying that they have a problem with either vaccination or testing. How do you kind of square that circle? Because that becomes really difficult. And I think we see this playing out in the election and other places, is the people that are getting their vaccines and want to get back to normal are prepared to do that. We seem to be chasing around a much smaller segment of society. But how do you, as an employer, how do you actually accommodate that when you've got the responsibility to keep all of your employees safe, not just the ones that are vaccine hesitant or refusing to test?
Well, at the end of the day, we are not required to accommodate non-human rights protected ground reasons. When it comes to the continuous refusal of an employee to follow a policy, the employer has the choice. The employer will have the choice of terminating that person's employment if no other measures are possible. And remember, I mentioned there's administrative controls, there's physical controls, right? So there's lots of environmental controls. So there's lots of measures that the employer can consider. If none of those will work, the employer at the end of the day has the choice of terminating the employee's employment. And whether that termination is done on a with cause or without cause basis, it's a risk that the employer may be willing to take.
Yeah, and I guess that's. I think you've answered my question in this way, which it seems to be from the questions that are coming in. We've got quite a number in the question and answer boxes. There's no way to take all the risk out. If someone wants to, and we see this, as employers all the time. If someone wants to be, challenge everything you're doing, there's very little you can do about that. But ultimately, employers have to make a judgment call about how they protect all of their employees, and sometimes that means making that difficult decision, like we would with employees that don't show up for work, don't follow directions, work unsafely, which puts you at risk of WSIB or putting other employees at risk. Many of us would have had to let employees go. This falls into, it's an extraordinary set of circumstances, but the choice to terminate an employee who you cannot accommodate for legitimate reasons or aren't following the rules, that's a normal, I think I hear you saying that's part of the normal process.
Well, I'm a little concerned about the use of the word accommodation. As long as we're understanding that people who have valid human rights protected grounds for refusal have to be accommodated short of undue hardship. If we're not dealing with human rights protected grounds, then yes, your choice, your liability is from the perspective of wrongful dismissal and whether you're going to terminate them with or without cause. Okay.
Here's one. We've got to what happens when people are wanting to come back, but how does an employer, would an employer respond, or what are the questions that an employer should ask to an employee who refuses to return to work in the on-site setting because of their fear of contracting AIDS? Like, I want to work at home because I'm concerned about getting that. And I think we do see this from time to time. Not everyone is eager to go out yet. And that would be both in a personal sense, but also from an employer. How does an employer respond to that, hesitancy of going back to the workplace in the first place?
Absolutely. Yeah, that happens. And, the first step would be for the employer to remind those hesitant workers that they are following all public health guidelines to protect them in the workplace, educating staff on the latest vaccine information, how to work safely, and what steps are being taken to protect them should clear up most concerns. If an employee then continues to refuse to return to the office, or an employee says that they refuse to work next to an unvaccinated employee or a person that they don't know their vaccination status, then they may be subject to discipline. Generally, employees cannot refuse to work due to a general risk and would have to demonstrate that the specific workplace is deemed unsafe in order to be successful in a work refusal. If an employee doesn't want to return to work and there's no valid reason, then it will be up to the employer again to either work out an arrangement for this person or deny the request and decide on the consequences, which could include discipline or termination of employment again. There may be situations, though, where an employee will legitimately have concern and should not return to the office based on medical, which are human right protected grounds. And these employees, if they are not able to work from home, then these employees, again, are entitled to IDEL under the ESA, infectious disease emergency leave under the ESA. Some of the grounds would be that the employee is under individual medical investigation, supervision, or treatment related to COVID. And the employees have the right to be on IDEL for as long as the event that triggered the entitlement continues to last. And then after the triggering event is over, let's say they recover or the COVID-19 is no longer designated an infectious disease, then the employee's normal obligations to be at work will resume.
So if someone is making that claim that that it's human right, that it's a protected or they've got some issue, we often would run into this in many different ways of what's the responsibility of the employer to either get a doctor's note so that you can verify. I mean, that's part of it. Just saying, geez, I'm not answering your question because of human rights is not enough. I mean, what are some of those specific things? So if it's specific to a medical condition, which is a protected class or something that is medical in nature, do you require a doctor's note to make sure that you've done that and then go about trying to accommodate based on that?
Well, any time that we're dealing with an accommodation issue, the employee has to prove that there is a protected ground, needs related to a protected ground that require accommodation. So the proof will be, again, dependent on the circumstances, but an employer does not have a blanket duty to accept an employee's statement right, just because the employee said it, right? So it's,
that's COVID, and that's COVID, but it's also at any time.
That's right.
Yeah.
Now, entitlements to infectious disease, entitlements to leave under the ESA have certain requirements with respect to what we can ask under the ESA for the entitlement to the leave. But from a human rights perspective, the employee has to demonstrate that there are human rights protected needs that need to be accommodated, because the code does not require an employer to accommodate personal preferences, only human rights protected needs.
Okay, we're coming towards the end of our time. This has been a fascinating discussion, I think very helpful for many, and I can see from the questions that are coming in from a variety of attendees that there's a lot of questions around this. But I want to get at something which is on the minds of a lot of folks. Can employers restrict or give any direction about employees off-duty conduct? Depending on where you work, it can be really, you can have a very safe workplace. You can put a lot of procedures in place, but if someone wants to go out and be in big congregate settings, and sometimes these things will just become aware because people are foolish enough to do things that they shouldn't be and then post it on social media. But what is the ability to give direction in non-working hours? I think I know the answer, but want to hear that. But also then, when you become aware of behavior that might be or activities that might put that employee at risk, and put by the follow-on putting your other employees at risk, how do you address those two situations?
Generally, no, an employer cannot restrict an employee's off-duty conduct unless a nexus can be established to the workplace. And so, for instance, the employee's off-duty conduct places the reputation of the employer into disrepute, or the employee's off-duty conduct is, completely inconsistent with the type of position that they carry on for the employer, and it's a known position and they're prominent. So, pandemic related issues may have some correlation to the workplace. Way back when the pandemic, I think it was last year, we might have seen on the news that there were certain individuals who work in hospitals and had different positions within the hospitals that were being reprimanded based on their off-duty conduct. Again, it will depend on the circumstances, but again, the two things is a nexus to the workplace and it's placing the reputation of the employer into disrepute.
Okay, I missed one question that came in through our chat. One was around the employers providing education sessions for those that are hesitant. Yeah. Is that a responsibility of the employer, or is that just something that you may be wise to do if you have valued employees who you want to continue on and don't want to go down the path? Is that something that you have to provide as an employer, or as an option? And who would be, what resources should people look to make sure they get the right folks doing that education?
So some employers are using that as an alternative to vaccination. You have probably seen in the media that some employers' policies is you will get vaccinated, or you will attend an education program on COVID-19 and vaccinations. Some employers are doing that program during work hours. Some employers are requiring that program to be done on their own time. As a general rule, no one should delve into something that is not their specialty. So if we're going to provide an education session, it shouldn't be you or me that is talking about vaccination. It should be a qualified person. Yeah.
Okay. Now, one thing, I know the schools are open. We're all keeping our fingers crossed that they stay open for those of us that have kids. But we'll see how long that lasts. We're seeing infections in schools are climbing up. So some parents have opted for that remote learning for their children to begin with. So their kids are continuing to stay at home. Are there any risks, or what should employers be considering for what, as they know that there are some employees that have kids that are staying at home, and by definition, I guess that employee may want to work remotely because they're in that situation. Just talk a little bit about that remote learning piece, because it was more of an issue when most people were home, or virtually everyone, because schools were closed. But I think that's an important one for us to think about, to have some understanding about.
Yeah, absolutely. So this again goes back to IDEL, Infectious Disease Emergency Leave Entitlement under the ESA, and it also touches on human rights obligation, because childcare obligations can fall under the ground of family status under the Human Rights Code. So employees who are unable to work due to COVID-19 related to school or daycare closures, if they happen again, which, as you said, I'm crossing my fingers that they don't, or because they have chosen online learning, are entitled to infectious disease emergency leave under the ESA. IDEL is unpaid except for the 3 paid IDEL days, which are currently available until the end of the year. And it's a job protected leave under the ESA. This means that an employee can remain off on the IDEL without the risk of losing their job. And the IDEL has to be for providing care or support, which we talked about this before, right? So I mentioned before that it's either elder care obligations or minor children obligations. Also, we have to note that the Education Act has been amended to allow for remote learning, and IDEL applies to those situations where the parents have made the choice to keep their children in remote learning. So even, school boards across Ontario will be required to offer virtual learning for the entire duration of the 2021-2022 year. So we may see people now, the entitlement from a human rights perspective too, and from the IDEL perspective, is providing care and support. So we might get into tricky situations when someone says, well, I need to stay home because I need to provide care and support to my 14-year-old child who is choosing to do online learning. We may have to dig in some more in those cases to see if this is actually providing care and support, and if this is actually something that falls under the ground of family status. So we have to consider whether we need to engage in accommodation. So for instance, if the employee is asking to work remotely as opposed to taking an infectious disease emergency leave, if we're dealing with family status, being in a parent and child relationship under the Human Rights Code, we will have to consider engaging in an accommodation analysis to see whether we can do something to alleviate some of those concerns. So some examples of accommodation may be providing flexible scheduling, it may be allowing alternative work arrangements, but again, employers have no obligation to accommodate a personal preference.
All right, this has been a fascinating, I think we're actually just on time. I wanted to thank you, Melissa, for doing this. And I think the important part of this is we're all getting through this together, lawyers, government, employers, and employees. So asking a lot of questions and explaining your own set of circumstances is critically important so that you do the right thing for your own business and you protect yourself. So very helpful to, especially from have your perspective today of the things to consider and the questions to ask that you should be considering during these difficult days. So thank you for Melissa for joining us today. We really appreciate it, and you taking the time out of your busy schedule.
It was my pleasure. Thank you for giving me the opportunity to chat with you and answer some of the questions. And, we'll have to stay tuned because this is changing at a very rapid pace. And, I can see that there will be decisions that are going to start going up to the courts. It's just that, even with COVID, our systems, the priority right now is on criminal and family matters as opposed to civil matters, right? So we'll get more guidance hopefully soon.
Well, we will have you back because as things change, we'll be, as always, Chambers and the Chamber Network will be there for businesses right across the province and across the country. So as we wrap up today, it does bring us to the end of today's session. Thank you once again to our title sponsor of the series, Manulife, our platinum sponsor of the series, the Immigration Partnership of Waterloo Region, and our September's sponsor, Gowling WLG, and of course, to Melissa for joining us today. And finally, to all of you for joining us today. As a reminder, we do host a new Business Success Series session every Wednesday at 1 p.m. Next week, we'll be joined by Danielle Servan-Gill from World Education Services, who will provide an update on the initiative introduced this spring, aimed at activating local employers to co-create practical and easy to implement solutions to address the barriers businesses face when tapping immigrant talent, which is so incredibly important to our workforce and will not only today, but moving forward. So we hope to see you then. For full details and to register, please visit greaterkwchamber.com. Please do share this series with your friends and colleagues, and do join us every Wednesday afternoon for another edition of the Greater KW Chambers Business Success Series brought to you by Manulife. Because if it's Wednesday, it's the Business Success Series. Thanks so much for joining us today. Have a good day.